I think.
Hold on.
Okay. All right, good morning. Welcome to Salary Board for March 1st, 2023. We don't have any signed up for public comment, so we'll move on to approval of the minutes from February 1st, 2023. Any questions or comments regarding the minutes? If not, is there a motion to approve?
So moved.
Second. All in favor?
Aye.
Aye. Okay. Approval of Salary Board actions. We have quite a few we're looking at here. Let's start with our friends from across the street. We'll begin with courts and adult probation.
Morning, everyone.
Morning.
It's probably easier if I let Christine Schenk address the adult probation and parole matters. She's intimately familiar with the workings of the office and the need for those things. We've discussed them previously, but I think she can discuss them in a much more succinct manner, and I don't want to take up too much time.
Okay.
Good morning. Thank you for this opportunity. I would like to start not in terms of the order on the list, but with order of priority in terms of our needs of our department. And so the first matter is the change in title from an existing position, that of our clerical supervisor. My original proposal was to rename that position Office Operations Manager, but after some questioning from the controller, and I understood what some of the questions were referring to, I would like to amend that title to Administrative Operations Manager. I do believe that it's more reflective of the unique role to the county and the department, and specifically the responsibilities associated with the position that are being done right now. This would be a salary increase of what I'm asking for, $4.81 per hour with no fringe. Even though the max cap would be higher than that, we're not looking to give that person that much of a raise. The current job, yes, started off as a clerical supervisor position, but over the last 4 years that I've been in this position as chief, it has grown and evolved beyond the scope of clerical supervision. Currently, this includes the oversight of 11 full-time positions and 2 part-time per diem positions. And the job has extended to overall management and support of department operations over 4 office locations. It's comparable to positions with like responsibilities in other county departments. Most departments have a separate clerical supervisor and office manager. This one position would do all, and I would suggest would save the county money by changing this title and increasing the compensation for it. Responsibilities include payroll, which has become increasingly complicated due to union contract requirements, maintaining department employee files, that includes FMLA and medical files. We're required to have fingerprint and background check requirements for our staff. Specific knowledge of the Pennsylvania Sentencing Commission database, known as SGS Web, and the reporting requirements that we are mandated to comply with, as well as knowledge of the Pennsylvania Justice Network and its data requirements, and in light of the ongoing opioid lawsuits, knowledge and understanding of litigation hold requirements, which are related to our adult probation records. As I said, this is an alternative to asking for another position, and so that's that request. I don't know if you want me to go through all 3 of mine, or if you'd like to do them separately.
What's the preference of the board? Is here all 3 at once, or here all 3?
I just wanted, we could do one, just questions on one at a time, if that's okay. But we can rule on them at once if that pleases the board, or the chair. I just also wanted to add, and thank you for addressing my concerns, because when the original title that was proposed, I did search the Manning table, and I did search the office managers and supervisors position, and found that this particular job was really right in line with the rest of the county. And you explained the unique knowledge base that this job requires. And that's the justification for the higher salary. And the certain compliance role in addition to the managerial role. And so you've addressed my concerns.
All right, so any other questions about that particular presentation? No? Okay. Ms. Schenk?
So my next request is the addition of a probation and parole supervisor. We had a successful department realignment in 2022, which created equitable and manageable caseloads for our general supervision officers. However, it created a burden for our supervisors who are currently at a 1-to-9 ratio in addition to their other responsibilities in the department. Counterparts, as you'll notice in the graph that I provided to you this morning, of like-sized counties have ratios of 1-to-6. Some counties, you'll notice, even have assistant supervisors on top of supervisors. If we were to get this position, it would put us to a 1-to-7 ratio, which would be much more manageable. We are a research-driven department. That kind of approach to probation and parole supervision is not only the right thing to do in terms of community safety and reduction in recidivism, but it's also mandated by the state. If we divert individuals from incarceration, that requires programming. And good programming requires supervision, and good quality programming requires proper oversight. So the supervisors need more time. There needs to be a more reasonable ratio of officers in order to ensure that supervision services are delivered with fidelity. This will ultimately decrease violations and subsequently incarcerations, which would mean less recidivism. So that's my argument for that position.
Comments or questions on the that proposed addition?
Do you want to talk about the way you would fund those?
I could, after I get through the last one, I'd be happy to
Okay.
do that. Absolutely, because I can. Our budget is able to absorb these additional costs. The last request is the addition of a case information and compliance coordinator. This is a non-union, non-exempt position that is basically between a clerical and a clerical supervisor position in our department. There's a great deal of data entry and data reporting that's linked to funding and is also legislatively mandated. Specifically, we get grants for restrictive probation. We also get grant in aid, which is now known as Continuing County Adult Probation and Parole Grant. And that requires quarterly reporting of our data, even though we're entitled to those funds as a county probation department. The Pennsylvania Sentencing Commission requires the reporting of all probation, restrictive probation, and revocation outcomes, as well as the generation of resentencing guidelines for certain cases, and then reports our compliance to PCCD, who's making the grant funding decisions. The need for quality and accurate data reporting affects our ability to receive those grant funds that we seek, as well as the ones that we're entitled to. Finally, I had spoken during the budget process that the warrants from the Sheriff's Office, it's their intention to move about 2,600 adult probation and parole warrants from their total responsibility. I believe they have about 8,000 warrants right now, would be transferred to our originating agency identifier, also known as an ORI. We're really the only court department that doesn't manage our own warrants. Domestic Relations does, so does juvenile probation. This would create a data compliance obligation to the Pennsylvania State Police, as well as to the National Crime Information Center, thus requiring the need for additional resources to be able to do all of that. In terms of being able to pay for this, I can certainly speak to that. We have been granted funding for one of our drug court positions, full salary and fringe benefits through the recent opioid settlement, which would be for the life of that settlement, which right now would provide for about $122,034, okay? That's one salary and fringe, one employee that you currently don't need to worry about. In addition to that, our GPS revenue, the amount of money that we are bringing in, don't really look at it as revenue, but the ones that are getting restrictive probation or paying for electronic monitoring has exceeded our budget projections. Last year, we were $125,000, almost $126,000 over what we had projected. We are on schedule to do the same thing this year. Again, enough money to cover the request that we are making today. In addition to that, we normally have a vacancy factor in our department, aside from what is normally given to us. We had 2 openings in 2022, which took us several months to fill. These positions that I'm asking for here will take us several months to fill, even though we're asking for them to be effective this month. And that will also generate savings. And finally, we get over $920,000 from PCCD for that continuing adult probation and parole grant that is $920,000 worth of salaries that the county is not responsible for. Thank you.
Okay. All right, comments or questions regarding the three proposals from adult probation and parole? No, I appreciate the thoroughness. I appreciate the, especially explaining how to pay for it. No, I never really like to vote for things that we can't pay for, and adding positions, so I appreciate that. If there are no questions or comments, is there a motion regarding items 1, 2, 3, 4 on the court-related department's salary board?
I'll make the motion that we add a case information and compliance coordinator, and that we add a probation and parole supervisor, and that we amend the title from clerical supervisor to administrative office operations manager at the increased salary indicated on our submission.
Motion made. Is there a second?
I'll second, but I just want to slightly change that title to, I believe Christine said Administrative Operations Manager? Okay.
Yes.
I think Your Honor said Administrative Office Manager, so I think it was just,
I'm reading from it, yes. Thank you.
just a slight difference, that's all.
Thank you for clarifying that for me.
Okay.
Okay.
Got just one question. The salary increase, it appears to me from $33.73 to $43.
That is the max, Commissioner.
That's that's 20,000, right?
Yes, I understand that. That would be the cap. We are actually proposing that this person get a $4.81 raise per hour.
Okay, thank you.
Yes.
But the next year, they could conceivably get another $10,000 raise.
Conceivably, but I don't see us doing that.
But the position has changed significantly.
It has.
Okay. And I know we've discussed that. I just wanted to make sure it was very clear that the position has changed dramatically. It's not a clerical position.
Yes.
Okay.
Okay, all right, so we have a motion and a second. All in favor?
Aye.
Aye.
Any opposed? All right, thank you, appreciate
Thank
it.
you.
Okay, court stenographers, items 5, 6 on the court-related list.
Yeah, what we're referring to here is our supervisor. I'll give you some historical background. 15 years ago, our supervising court stenographer made $6,500 more than those people under her. Now it's down to $4,500 in salary. Presently, 18 of the 24 make more money than she does because they can do transcripts. They get paid for the transcripts, as you know. So we have a rule of judicial administration which requires our supervising stenographer to keep track of all transcripts in time for all the court reporters, and so that she is unable to do transcripts or work in court as often as the others. This, as I said, leaves her making less than the people she's supervising. So we're simply requesting that we raise her cap so that it would more accurately reflect the difference between her position and those under her. I think the request is to move the cap up $11,500. And again, we're not going to give her all of that immediately, but we anticipate giving her a slight increase as a result of that.
Okay, comments or questions? All right, and it's obviously something you have budgeted, you're able to absorb the costs.
Yeah, as you know, we've been under budget almost at least every year that I've been president, Judge. I think we were under budget before that, but I can't speak to any specific numbers.
We certainly hope it stays that way when you're no longer president, Judge.
306 more days, Commissioner.
All right. If there are no questions, then is there a motion to approve the salary increase for the supervisor and coordinator of court reporters, items 5, 6?
So moved.
Second?
All in favor?
Aye.
Opposed? Okay. All right, thank you.
Thank you.
You want to do
Go ahead.
yeah, 7, 8, 9, 10, are they kind of basically the same thing, it seems like, right?
Yeah, they're all the same.
Yeah.
We have 2 vacancies in the magisterial district justice courts right now, and we'd like to move them over to the supplemental side, in other words, have floaters so that we can move them around to fill the needs of district courts when people are out sick, when they're on vacation, when there may be a slight increase in volume for a particular period of time. So we'll move those people around. We don't want to come back and ask to add positions. We think we're more efficient, it'll be more cost-effective to do it this way. There's no change in salary. We're just taking 2 of them that are regularly assigned to 2 district justices and moving them to court administration where they'll serve as floaters and work in different courts.
Okay, any comments or questions? Okay, and I'm assuming the 2 district justices are aware of these
Yes,
changes?
they've been vacant for some period of time. We didn't fill them. As you may know, the Administrative Office of Pennsylvania Courts has a guideline that we should have so many clerks for the number of case filings. These are courts where the case filings have been slightly lower than we believe the need is, and they haven't been utilized there for some period of time. The courts won't even notice.
Okay.
Until I tell them.
All right, is there a motion then for items 7, 8, 9, 10 on the court list?
I'll make the motion to move the 2 vacancies into the flex or supplemental part of our, court administrator's office.
Second.
Motion made and seconded, all in favor?
Aye.
Opposed? All right, and lastly, the bail review officer.
Yeah, as you may recall, this was a pilot program, and I have a report from Mr. Bidlingmeyer. And since February, he's reviewed 334 bail matters. He's been able to reach 119 recommendations to lower or modify bail. They've been agreed to by the district attorney and the defense attorneys. And so those 119 cases have been modified in a much shorter period than it would take to get them before a judge. And I noticed the district attorney's here, and I want to thank him for his cooperation in having someone assigned to that as well. I think it's been very successful. And what's really important about that is getting the people out of the institution, and with the modifications of bail, it allows us to get them into treatment, typically drug and alcohol. We get them screened much faster and into programs and into the treatment programs much faster. So in my opinion, it's been very successful, and I'd like to keep it and move it from a temporary to a permanent position. And I think I saw Director Kratz here earlier. I don't know if he's still here. He may have additional information if you have questions about how its impact upon the institution.
I have a question, but it's not about the impact. I know the impact has been successful, and so, I mean, this has worked well. I just thought we were doing this kind of because we knew there were problems, and at some point there will be bail reform acts possibly passed. At some point we may have different district justices where this position might not be useful or even necessary. And I wasn't ready for a pilot to be done in a month, I guess. I thought we were going to pilot it for like 6 months or something. So I don't know. I would prefer to either continue the pilot or to sunset this in some fashion, or to have it come back up in 3 years or something to see if it's still necessary. I mean, we kind of came up with this because we had a problem. So if the problem goes away, then what?
Frankly, I don't know if the problem's ever going to go away. I mean, we've always had bail applications. We do them on Tuesdays and Fridays, and the lawyers come in with a stack a foot high. We've had that for some period of time.
So you've always had them, but we didn't always need this bail review officer.
Well,
The bail-
I don't know if we never needed one in the past. We have one, and now the applications are fewer. I think the one point that is made in the memo from Mr. Bidlingmeyer is that we're seeing more people getting into treatment. And so as long as there's a need for treatment, I think this is a good program. And that's why I say I don't know if it's ever going to get better.
Well, a lot of times we do sunset things, or we ask people to come back in 3 years or 5 years or whatever. to assess whether that position is really necessary. It is my hope, and I keep hearing, isn't there supposed to be all kinds of bail reform coming down? What if it does, and we don't need this position? Or we need it in a different way or something?
I'm not sure I can answer that. You're asking me to speculate, and I can only speculate based upon the data we have. And as long as I've been a lawyer and a judge, we've had plenty of bail applications. We've had plenty of people in the jail, and most of them, at least today, are in need of some type of treatment.
Any chance you'd be willing to continue it, like a normal pilot study, 6 months or a year, and just see how it is? And
I would just like to add, just bouncing off of Commissioner's comments, and one of my concerns is, you know, you have someone in that position. If this position continues as a pilot program, does that jeopardize employment of the person that's in there? In other words, will you not get a quantity? I don't know. I'm just asking you, is that a problem on your end, making sure that that position is filled with a competent person to fill that position, to do that position?
It may be, but I think Mr. Bidlingmeyer's committed to remaining in the position. You know, we've had a conversation about that. I can't emphasize enough how much he's done and how committed he is to it. I don't know, maybe Mr. Kratz can add something to that. I don't know.
I don't think that's the question. We know that it works, but we also know that we had that this was a specific idea because there was a problem. And the problem could very well not be there at some point.
Sure, anything's possible, but I just can't envision the problem going away.
Well, we didn't used to have it. It was acceptable, then it became, you know, kind of ridiculous. So we dealt with it. That's why, I mean, I think it's necessary right now. I just don't think it's fair to hamstring future boards on this, or this is one of those positions that like 20 years from now, people will say, why'd they ever do this? And, you know, what does this person do?
Oh, I think we have lots of positions throughout the county where 20 years later, the positions are not filled or.
Right. So I would suggest that this be sunset, and if there's a reason in 3 or 5 years that this hasn't been corrected, then they'll just continue it.
I'm in support of, you know, if Your Honor makes a motion. I don't know about I hear you, but, and I respect your opinion.
I mean, the person.
I
who has
just,
a permanent
I do
position
think
then-
it's speculation, and there's a need, let's fill the need.
Well, are you fully aware of what the need was, like what was going on? Because maybe we should talk about that sometime.
Well, I've heard you several times,
I
yeah.
don't think I've ever said it in a public meeting, but,
Oh.
okay.
Well, I'm talking about leading up to meetings, yes.
Sure, yeah.
Yeah, I don't, Your Honor, I don't know if it would be appropriate, but I would maybe like to hear from Dave Kratz from Corrections, to maybe hear from him what the impact of what has happened so far affected what he does, if that would be okay?
Sure.
Good morning. Yeah, I can say this program has been successful, and I can tell you, the few things that really have driven it is, one, the speed. Previously, if a person came in, and let's talk, these are low-level offenders. Most of these low-level offenders are drug and alcohol problems. They're a challenge for the jail. If they were to come in on a Sunday night, for instance, by the time they would get their bail review done, it would be a Friday. We are trying to get people to treatment more. A lot of these RORs, R2 or unsecured bails, R2 treatment programs, inpatient. And when a person's, with us for 5 or 6 days, they're detoxed sometimes. And then that is impossible to get them, not impossible, it's more difficult to get somebody in with an inpatient setting. So we're seeing people coming in on these low-level cases, getting that bail reduction. The district attorney's office is involved. We're talking, again, low-level offenders. I don't want to scare anybody. We're not talking about people, with victims. And we're able to get these folks to inpatient. So, I mean, that's the one success. That's something we need to grow upon. The other piece is hospitals. We're seeing a lot of these low-level offenders end up going to the hospital because they have a lot wrong with them. And again, we're able to get those folks out and linked. If they're already in a hospital, they could be linked to inpatient, they could be linked to the treatment they need, but not basically under county supervision. So that's really what's been working for us. Our population numbers reflect a positive change in that area. I really can't speak to the bail reform. If it comes down, we are going to have to, look at who's coming in the door. I don't know if it's going to change or not, but right now it's working. It's definitely working.
I mean, maybe, does the situation ever arise where the person comes in withdrawing or close to withdrawing, and you start to detox them, and maybe the person can't afford the bail that's been placed upon him, and let's say the bail gets reduced the next day or 2 days later and they're in the middle of detox, does that create a problem that you need to release the person early before he's been really detoxed, and which might create a situation where if he's not fully detoxed, it might put him in jeopardy of being released and going right back and, buying drugs again. And all too often when people are, off of drugs for a while, even if it's only a few days, and they go back and use the same dose of whatever, heroin or methamphetamine that they were using before they come in, they put their life in danger, really. So has that been a problem, or?
I think what we've seen is actually an improvement in the old system, basically with the Tuesday, Friday bail reductions. Again, we want to get these folks to linkage. These are, again, not high-level offenders. They really should not be locked up. They should be diverted and sent to inpatient facilities to detox and deal with the drug and alcohol. So now, on a Sunday night, if we get that order on a Monday, we are detoxing that person. They can continue that detox inpatient. My understanding from my drug and alcohol folks is while they're detoxing, that's the easiest path into an inpatient bed. Once they're detoxed, it's more difficult to get inpatient, and also, as we all know, inpatient leads to the outpatient treatment. Now, whether they follow through, I don't know, but I think, that's our best chance with a lot of these folks, to identify them, get them into inpatient, get them out of the criminal justice system, and let them start down that path. So I think we're more successful at getting them to treatment with this program. And if it continues, that's something, that's a goal of ours, to continue that on, build some relationships with some of these providers and break down some of the barriers to moving folks to an inpatient bed.
Okay, thank you, Dave.
I would just like to add, because I hear what Commissioner Marsegli is saying, and I understand her concerns. Would it be perhaps, could this position be reevaluated if, put it as a condition, I guess, for the position, if and when legislation is changed? Would that satisfy you, Commissioner? In other words, not an automatic sunset of 5 years, but a sunset, if I hear you correctly. In other words, a sunset and/or reevaluation, I guess, would probably be of the position need. If and when legislation on bail, if there is some sort of bail reform legislation passed.
The only thing with that is that, that makes sense. I don't know how that works into our system. So would the courts, do you have someone that would remind you that you need to come back before salary board because that law was passed?
I'm sure you'll remind me.
It's possible I won't be here by the time they get that passed.
Yeah, once again, I won't be president judge after this year, so we'll have to see that the new president judge is reminded.
It's sort of, once it leaves here, it's a court thing, and it's out of our hands forever. So.
Yeah. Can I just clarify something for Commissioner DiGirolamo? When we talk about, and when the director talks about the bail being for low-level offenders and the bails being reduced, they're not necessarily walking out of the jail on their own. Many times what we've been able to accomplish is a modification which allows them to leave the jail to go to treatment. That would be a condition of the bail. So they're not leaving unconditionally. I don't know if that was clear.
So you're saying, Judge, that with the bail reduction, the judge overseeing the case can make going to treatment
Yes,
like a mandatory thing upon their
Yes.
release?
yes.
Okay.
That's what Director Kratz was talking about, how with the drug and alcohol people, they help them detox and find a program. Mr. Bidlingmeyer will work with the district attorney and the defendant's counsel. Maybe we'll release them to an inpatient program, or we'll release them to an intensive outpatient program.
What happens to that person if he agrees to go into treatment, goes in, and in 3, 4, 5 days leaves?
It's a violation of his bail, and he may end up back in the institution.
Okay.
All right. I'm sorry, I didn't mean, so I'll do what's necessary to keep this program going. I don't know what I'll be able to do after my term is over, and that, because then it's not up to me, Commissioner.
A question I had, do you know, you might not, I don't know, do other counties have a position similar to this in terms of?
Yes.
They do, okay.
Philadelphia has, as far as I know, all bail matters go before different bail commissioners, and they do them every day. I don't know if maybe the district attorney's aware. I know this isn't his fight, but maybe he's aware of some other programs. I think, I know Philadelphia has it. I'm not sure about other counties. Do you know?
Okay, all right.
I know that other places have very similar programs. It's, you know what it's part of?
I'm sorry, I have to use the microphone. Sorry, I have to use the microphone, Judge.
I'm sorry, sure.
That's all right.
I mean, most of the counties that have reentry programs, and we're in the process of doing that, use this type of thing. I mean, the main purpose to me that I see that this does, people aren't detoxing in our jail. They're detoxing in an inpatient program, which really decreases our liability, because I don't really need to tell the commissioners how many times we get sued on prime care issues and detox type things. This just removes them from our jail, and, you know, our Department of Corrections then having to deal with them, either if they're in a hospital or whatever, and puts them into the inpatient program where they would then detox and start treatment.
Okay.
And if they don't detox and start treatment, they're back in jail.
Okay.
That's what happens. It's kind of like a forced incentive.
I do appreciate that. The reality is that we started this because district justices were sending people to jail with too high bails over silly things.
And they'll never stop because of the pressure on the DJs to stop crime in their district.
Well, it's not like it's all DJs. It was just a couple. But,
Okay,
so
I
here's
agree.
my point. We have a lot of positions, that especially if they're grant funded, where we ask Dave Boscola to come back to us in 3 years or 5 years when the grant runs out and eliminate the position. I'm just suggesting that we have this position such that you are to come back in 3 or 5 years and say, well, we still need it, or we don't need it. That's just, that's what I wanted. It's not that I think that you don't need it now.
We could certainly do that. I mean, we can come back, we can review it, we could review to the prison board. I mean, whatever you wanted to do, we'll do. I mean, the program's working though. It's up, it's running, and
So
That's
this is what I would suggest. This may not get a second, but I would make a motion to approve
Item 11.
number 11 to be to be evaluated in 2028, or it will be done.
Okay, so a motion made to approve item 11 to be evaluated in 2028? or
Yeah, March
before?
2028.
Be evaluated in March 2028 for continued presence on our Manning table.
All right, I'll second that.
Second, all right, motion made and seconded. All in favor?
Aye.
Aye.
Opposed? Okay, thank you.
Thank you.
Appreciate
Took
it.
us a while, but we got there. Thank you very much.
Okay. All right, keeping an eye on the clock, we do obviously have a meeting at 10:30, the Commissioners' meeting. We have quite a lengthy agenda here for this salary board. I'm going to ask District Attorney to come forward and make his presentation, and ask him to be conscious of time. And I'll ask the others who are coming after him as well to be conscious of time, not just picking on him.
Morning, salary board members. Bucks County DA Matt Weintraub. I would note for the record that that was the longest I remained silent even when called upon to make comment. I'd like credit for that. I have a number of matters before the salary board for your consideration. They essentially, they're all reflected on one sheet, but I'd like to break them down into two categories. Before I do that, just by way of overarching explanation, one of the issues that we've certainly experienced at the district attorney's office, and I couldn't speak for the rest of government, is we've had a brain drain. We've had an issue with people leaving before they've honored their word of honor, their 3-year commitment to us as attorneys, and that has caused I don't want to say a public safety risk, because we've not experienced that, but certainly a diminution in our ability to provide the excellent service that we provide in keeping people safe here in Bucks County. If you remember, a couple of salary boards ago, I came in here, I think it was even during public comment, and said, hey, let's not forget the people that don't have the benefit of union bargaining and negotiation, and let's try to keep them on par with how well the unions have done. So you all heard that, and you made a great evaluation and gave everybody a 3% raise this year that was non-union. One of the things that I've been able to do internally, almost to completion, but not yet, and that's part of the reason I'm here, is to try to raise my non-union, non-attorney personnel salary so that if they're in positions of leadership, that they avoid compression with the people that are below them, as you've heard Judge Bateman explain with the court stenographers, or we have a couple of sort of unique positions that are non-union where they just they're subject to the mercies of whatever the COLA is for the year. So in a number of those instances, I've had the ability to give them raises within my budget, and I would note that everything that I'm about to propose is within my budget, so they will be budget neutral. In one instance, will be budget positive for the county. But there are 6 positions where I was not able to give those people the equivalent of these bumps that I thought that they've earned, and also to avoid compression because they're at their caps. So it's, I know we're not supposed to conjure individual people in these positions, but rather address the positions before salary board. But this is just a question of fairness here, board members. I am asking that you raise the caps for the 6 positions that appear before you so that I can spread, and I will tell you, I have $10,000 reserved among the 6 that I've saved as part of the budget shifting and reallocation of money, so that I can then make them whole, help them avoid compression, make sure that they're being paid commensurate with 2023 salaries to try to avoid brain drain of my support staff. So that's the essence of what I'd like to do with those 6 positions. It makes sense to me for me or for somebody to make a motion about those 6 positions to raise those 6 caps, unless you want to deal with them individually. That's what I'd like to do.
Let's deal, what's other questions in general about these 6 positions and the DA's recommendation? Okay, that makes sense, I think, to do them at once.
All right, thank you. So I would like to make a motion, Chairman, to raise the caps as you see on my proposals that I've submitted for those 6 positions to those new caps as reflected on the paperwork that I've submitted.
All right, so that's items 1 through 12 on the Row Office District Attorney's page. Motion has been made. Is there a second?
Second?
All right, all in favor? Aye. Opposed? Okay.
All right, thank you. Part 2, equally as important here. As I've expressed earlier, we were at a situation where many of our people, now I'm talking about attorneys, were fleeing. The work is hard. We're in the midst of a transition, which we have endorsed, we've been proposing for years, in which the court has now put us in individual calendar systems. I think it's a great move. There, of course, have been some bumps along the way, and I think some people candidly just got scared, but one of the issues, I'm talking about attorneys, one of the issues that we have had, and this is across the state, is we're having difficulty filling ADA positions, and we are having difficulty maintaining our talent level here. The last thing we want to have happen is where we have to go picking from the bottom of the barrel people that finished last in their law school class that couldn't pass the bar exam the first 4 times, and they're the ones that are protecting us from the burglars, the rapists, and the robbers. I'm not saying they can't do it, but I want us to be able to pick from the top rather than the bottom. So as you know, one of the things that I've done is increased our entry-level salary to make it just equal to that of our brothers and sisters in the public defender's office, not more, just equal. We were below them. And one of the other issues that we've addressed with your help and cooperation is avoiding compression, and I've done this in many creative ways by shifting money, by getting grants, et cetera. I understand that everything has a revenue component to it, or a budget component. So one of the things that we have thought of to creatively address this issue, to frankly reward people that have honored their 3-year commitment, is come up with a retention stipend. This is not paid in anticipation. This is paid as a result of, hey, you told us you were going to stay 3 years. You've given us 3 or more years of great and honorable service to the people that you've sworn to protect and serve. So by way of explanation, what I propose to do is to give any attorney that has remained and honored their commitment for 3 years or more a stipend of $3,000. And I have 2 that are just shy, and I propose to give them $2,500 each. This is new in my department, but I would note that there is some prologue for this. I believe that the corrections officers got some sort of a bonus enticement, and some of the nurses at Neshaminy Manor have gotten a bonus enticement prior to honoring their commitment. These are all paid because they've already honored their commitment. I would note this is not only revenue neutral.
Can I
but
just stop
revenue-
you? Can I just stop you? The recording
Tape
stopped.
recording problem there. I think we have to,
I ran it out.
You ran it out,
Filibustered
Matt.
it. Filibustered.
Do you just flip it?
yeah, I think it's
Almost done.
Yep.
Good?
Good.
Thank you, dude.
So-
The last 2 points that I'll make, and I'll take that as my cue to wrap it up. We applied for many grants, but we applied for one grant that was exceptional, where we got $3 million to combat gun violence, straw purchases, crimes committed with guns. And in that was the equivalent to pay one of our deputy DA salaries to the tune of $87,000 plus the benefits package. So I have a person in that position. That money has already been granted to us. We're just waiting for the check, I think, to clear. And so my proposal is to, now that the county doesn't have to foot the bill to pay that person's salary, to take the equivalent of that person's salary, the benefits package is already yours via the grant, and to break it down in these $3,000 increments and the $2,500 increments. I would also point out, this is not a salary adjustment. This is not a raise. This is a one-time retention stipend. I should say, just so the record is completely clear, that if this were to, if we were in a position to do this again next year, we may come before you. I don't want to mislead you, but it is a one-time payment similar to that the COs got and that the nurses got. So that is my proposal. I'm prepared to make this motion, and I will certainly entertain any questions that you have.
the only question I had is with regard to this retention stipend, if, for example, you have somebody who stayed there 3 years, they get the stipend, what if they leave tomorrow?
They have fulfilled their obligation. This is obviously to encourage people to not leave before that. I'm going to approximate 6 to 10 people that aren't getting the stipend because they haven't stayed 3 years. So by rewarding the people that have stayed 3 years, they don't owe us a thing.
But will that create a system where anybody who thinks, well, I'm going to hit my 3-year mark in 2 months, so I'll get a $3,000 stipend too?
No, I've already explained this to them, that this may be possible. I think it's something to aspire to, but the people understand that this may be a one-off. I need the people that I work with to understand that I'm always trying to do what I can to retain them, but also to express to the people that have already walked out the door, I can't control them. There was nothing I could claw back from them. But I want to show the people that have yet to honor their commitment, if you stay, we will do everything we can to make sure that you're fairly compensated in a very, very competitive market.
Okay. Any other questions for the DA? All right, this is item 13 regarding the retention stipend. Is there a motion?
I would make that motion.
Second?
Motion made and seconded. All in favor?
Aye.
Opposed? Okay, thank you.
Thank you all, appreciate it.
Okay, Law Department. See, Ms. Fitzpatrick is here.
Good morning, members of the Salary Board. Amy Fitzpatrick, First Assistant County Solicitor. The Law Department is seeking 2 title changes. First, we're seeking a title change to position 7016 from Assistant County Solicitor to Deputy County Solicitor with no change to the union code or salary max. A similar request was made at last month's Salary Board meeting. The title change is sought so that the title can catch up with the realities of the responsibilities and the seniority of the person in that position. As the Law Department has evolved in carrying out the Board of Commissioners' vision for legal services, we have increasingly utilized the title Assistant County Solicitor to denote a more junior or onboarding attorney, whereas the title of Deputy County Solicitor would be associated with more experienced attorneys or those with particular subject matter expertise. The Law Department is also seeking a title change for position 1437 from Assistant Solicitor to Special Counsel, again with no change to the union code or salary max. By way of background, the term Special Counsel is often used in governmental contexts to reflect a limited role, and as such, this title change would reflect the Department's limited use of Union Code 77 attorneys to reduce the county's reliance on engaging outside counsel on an hourly basis. Are there any questions I can answer for the board?
Okay, comments or questions?
I have a question. Oh, sorry. So you mentioned no union code change for 77. It's a very high salary for 77 union code. Would you be willing to change that to 00?
I'm actually not seeking a union code change.
I know, I'm asking if you would consider a union a change to 00.
What would the implications of that be?
Well, I think 77 is typically used for, not in 100% of the cases, but I think in most of, it usually means elected official or solicitor to an elected official. The other 77 that you have on your Manning table is at $6,000 a year. You know, I think special counsel usually implies an hourly rate, but I think you're not looking to change the position, so it's still going to be a salary basis. And I think, you know, they're still going to be in your law department with benefits, correct?
Correct, but used in a very limited role. I couldn't have had a better introduction than the court speaking today so highly of Mr. Bidlingmeyer. In the past several years, we've had incredible success at keeping outside counsel bills down by utilizing attorneys like Mr. Bidlingmeyer, who have very particular areas of expertise. And rather than pay outside attorneys on an hourly basis, we're able to have, frankly, what is a very small salary compared to what those attorneys would be making in private practice.
And just for point of clarification, Ms. Van Blanc, the bail review officer that we just approved is also Code 77.
Right, I think he's making about half that, though.
No, it's, the wage is about the same. It's $5,000 less, according
I
to...
think the cap is the same. I don't think he's making the same. But he
Here, the
could,
expectation would be the same as it has. We're not seeking any change. So in the past, the hourly expectation, pardon me, is approximately half of 40 hours per pay period versus 80 hours per pay period. And this role is very, very specific. And that's the utilization of the title special counsel. As you and I discussed, it's really to either address very specific areas of the law that might not make sense to have somebody full-time specialized in those areas, or it's to reduce for the short term our reliance on outside counsel as we can staff up. We're understaffed right now, and as the Salary Board is aware, at last month's Board of Commissioner meeting, County Solicitor Khan indicated that he's going to be stepping down. So the utilization of a role like this gives us flexibility while we can fill litigation positions within the department.
So the person filling this position can have other work, other jobs?
Correct, and the utilization of that union code reflects that. As in the past, these attorneys could have outside work.
Okay. So $87,872 for an attorney to come in on a special, case or litigation or something?
Without speaking to the personnel matters, that would be the salary cap for the position. I would recommend that that remain the same, and I'm only seeking a title change for the position to reflect the work actually done by an attorney in that role.
Okay.
All right. Taking a look at items 1, 2, 3, and 4, is there a motion to approve those changes, title changes?
Second.
Okay, all in favor?
Aye.
Opposed? Okay, thank you.
Thank you.
Appreciate it. We have 2 more presentations. Let's see how quickly Mr. Kratz can speak. And then we'll move to Mr. Guide.
Thank you. I can go very, very quickly. I'll speak to items 5 and 6, the community corrections officer change to an investigator position. We agreed to sunset our community corrections officers' positions 2 years ago when the house arrest program ended, which we successfully did. We did keep one position around for a transition. That position's fully funded. But what we found was we need a 4th investigator. We have 3 investigators that handle internal affairs. They work with the district attorney, drug cases inside the jail, escapes. Those roles have grown. The 3 of those folks currently are really maxed out in their workload. And then we have to factor in this PREA, Prison Rape Elimination Act coordinator position and investigator. We've had a 2-year grant. That grant will end in October. We've had no luck filling the investigator position, and we recently lost our coordinator position. So that's been vacant, and our investigators have had to take up the slack. By bringing in a person at an investigator level, which is actually a little bit of a savings off the community corrections rate, we feel that that person could devote probably half their time to PREA investigations and issues, and then the other 20 hours to the drug and internal affairs investigations that we're seeing. And I can't say enough of how much of a drug problem we're all aware of what's going on with drugs in correctional facilities. So it's a constant battle. And that's my presentation on those 2. Do you want me to do the others?
How about we do, so you focused on 5, 6, correct?
5, 6, yeah.
Okay. How about, I think we have to vote on that one. I think we're going to have to recess and reconvene at the end of the commissioners' meeting so we can get through these. Is there questions about item 5, 6?
No.
Is there a motion to approve item 5, 6?
So moved.
Second.
All in favor?
Aye.
All right, we're going to have to recess. I'm conscious also of our IT staff that have to, AV staff that have to kind of turn us around to a new meeting. We
Commissioner,
have some people coming in, so.
If it does help the remaining items, we could put on the next salary board if you want. There's no urgency for those.
All right, well, we're going to have to probably come back for 911 anyway, so I'll entertain a motion. Well, we're going to recess the meeting at 10:25. We will reconvene the meeting at the end of the commissioners' meeting.